Myth number 7. If I am not free to leave in front of a police officer, then technically any consent that I would give for him to search, I was coerced because it wasn't really voluntary. The reality, even someone who is detained or under arrest can still give voluntary consent as long as it was truly voluntary under the circumstances. This is one of the biggest misconceptions so many people have. They think that if a police officer won't let them leave, then now they're actually being coerced, they're under duress, and they weren't really thinking clearly when they gave consent, so it should all be thrown out. However, the Supreme Court settled this situation decades ago. They said being in custody does not automatically make whatever you agree to involuntary. The test on voluntariness is this. The Supreme Court specifically said whether consent was given freely by the person's own will without duress or coercion, considering the totality of the circumstances. In the Supreme Court case of United States versus Watson, the Supreme Court upheld a consent search where Watson had actually been arrested and he was in custody and he agreed to a search of his car. The court specifically said that the consent that Watson gave was voluntary, even though he was never told that he could refuse consent. The Supreme Court went on to say that cops can request your consent during a traffic stop without ever telling you that you're free to go or that the traffic stop ever ended.